What happens when the government you elected decides your constitutional rights are negotiable? Right now, in Virginia, that question isn't theoretical anymore. It's reality. The Democratic majority in Richmond just pushed through a fresh wave of gun control legislation, and whether you own firearms or not, whether you lean left or right, this affects the fundamental balance of power between citizens and the state in ways most people haven't fully grasped yet. Here's what's actually happening beneath the surface. These new laws aren't just about background checks or waiting periods. They represent a calculated shift in how Second Amendment rights are being systematically redefined at the state level, while federal courts are still wrestling with major gun rights cases. Virginia has become the testing ground, the laboratory where progressive legislators are experimenting with restrictions that could spread across blue states like wildfire if they succeed here without significant legal pushback. But there's a deeper current running through this story that nobody in mainstream media wants to touch: the growing disconnect between constitutional guarantees and state-level enforcement. We're watching a real-time experiment in how far state governments can stretch their authority before citizens push back, before courts intervene, or before the entire framework of federalism starts showing cracks that can't be ignored. So let's talk about what's really going on in Virginia, because the headlines you're seeing don't even begin to scratch the surface of what this means for gun owners, for constitutional rights, and frankly, for the entire trajectory of how states are handling the Second Amendment in an era where the Supreme Court has supposedly settled some of these questions. Virginia Democrats just approved a new round of gun control measures, and I want to walk you through not just what these laws say, but what they reveal about the broader power struggle happening right now between state legislatures and individual liberties. First, we need to understand the context here. Virginia wasn't always a battleground for gun control. For decades, it was a solidly pro-gun state with relatively few restrictions compared to places like California or New York. But the political landscape shifted dramatically in recent years. The Democratic Party gained control of both chambers of the state legislature and the governor's mansion, and they immediately made gun control a priority. This wasn't some gradual evolution. It was a deliberate, organized push to fundamentally transform Virginia's gun laws in a matter of legislative sessions. And what we're seeing now is the continuation of that agenda, the next phase in a long-term strategy to restrict gun ownership through incremental legislation that chips away at Second Amendment protections, one regulation at a time. Now, the specific measures that just passed include provisions that expand background check requirements, impose waiting periods for certain firearm purchases, allow local governments to ban guns in specific public spaces, and create new liability frameworks for gun manufacturers and dealers. On the surface, proponents argue these are common sense safety measures designed to reduce gun violence and keep firearms out of dangerous hands. And look, I think we can all agree that keeping guns away from violent criminals and people who pose genuine threats is a legitimate goal. Nobody wants to see guns in the hands of someone who's going to commit mass violence or domestic abuse. But here's where the conversation gets more complicated and where the real concerns start to emerge for anyone who takes constitutional rights seriously. The problem isn't necessarily that these legislators want to reduce gun violence. That's a goal most Americans share regardless of their political affiliation. The problem is that many of these measures don't actually target the root causes of gun violence, and in some cases, they create legal minefields for law-abiding citizens while doing very little to stop criminals who, by definition, don't follow laws in the first place. Let's take the expanded background check requirements as an example. Virginia already has background checks for purchases through licensed dealers, which is the case in every state thanks to federal law. What this new legislation does is extend those requirements to private transfers, including sales between family members and friends in certain circumstances. The stated goal is to close the so-called gun show loophole, but what it actually does is criminalize behavior that millions of Virginians have engaged in legally for generations. Passing down firearms as family heirlooms, lending guns to trusted friends for hunting trips, or selling a personal firearm to a neighbor you've known for 20 years. And here's what really troubles me about this approach. It creates a system where ordinary people who have no criminal intent, who are simply exercising what they believe to be their constitutional rights, can suddenly find themselves on the wrong side of the law without even realizing it. That's not justice. That's entrapment by complexity. When laws become so convoluted that average citizens need legal counsel just to understand whether they're complying, we've crossed a line from legitimate regulation into something that starts to look a lot more like control for its own sake. And I think that's part of the point. When you make legal gun ownership so burdensome, so fraught with potential legal pitfalls, you discourage people from exercising their rights, even if those rights are theoretically still on the books. The waiting period provisions are another piece of this puzzle that deserves scrutiny. The argument for waiting periods is that they provide a cooling off period that might prevent impulsive violence, particularly suicide or crimes of passion. And there's some research suggesting waiting periods might have a marginal effect on suicide rates, though the data is far from conclusive and the effect size is generally small. But let's think about what waiting periods actually mean in practice. If you're a law-abiding citizen who already owns firearms, a waiting period doesn't affect your ability to commit violence because you already have access to guns. If you're a criminal intent on doing harm, you're not going to walk into a licensed dealer, fill out paperwork, and wait patiently for the government's permission. You're going to obtain a weapon through illegal channels. So who does this actually impact? It impacts first-time gun buyers, people who might be seeking to purchase a firearm for self-defense in response to a specific immediate threat. Imagine a woman who's being stalked by a violent ex-partner who's gone to the police but been told there's nothing they can do until an actual crime is committed, and who now wants to purchase a firearm to protect herself. A waiting period forces her to remain vulnerable during the exact window when she's most at risk. That's not theoretical. That's a real scenario that plays out more often than most people realize. But let's dig even deeper into what these laws represent from a constitutional standpoint, because this is where things get really interesting and where the implications extend far beyond Virginia. The Supreme Court has issued several major rulings on the Second Amendment in recent years, most notably the Heller decision in 2008, which established that the Second Amendment protects an individual right to keep and bear arms for self-defense, and the more recent Bruin decision in 2022, which established that gun regulations must be consistent with the nation's historical tradition of firearm regulation. That Bruin decision was supposed to be a game changer. It was supposed to establish a clear framework that would prevent states from imposing arbitrary restrictions on gun rights. But what we're seeing in Virginia and other blue states is a deliberate effort to test the boundaries of that framework, to see how far they can push gun control legislation before federal courts step in and say enough is enough. And here's the troubling part. Even when these laws are challenged and struck down, which many of them inevitably will be, the process takes years. Cases have to work their way through district courts, appellate courts, and potentially the Supreme Court. During that entire time, the laws remain in effect. Gun owners have to comply or risk criminal prosecution. Rights are restricted, precedents are muddied, and the legal landscape becomes increasingly uncertain. This is a feature, not a bug, of the strategy we're seeing from gun control advocates. They know many of these laws won't survive constitutional scrutiny in the long run, but they also know that the legal process is slow, that litigation is expensive, and that in the meantime, they can reshape the culture around gun ownership and create bureaucratic structures that are difficult to dismantle even after court victories. The provision allowing local governments to ban firearms in certain public spaces is particularly concerning from a federalism perspective. What this does is create a patchwork of regulations where the legality of carrying your firearm can change from one county to the next, from one city park to another, from one public building to its neighbor across the street. This makes it nearly impossible for gun owners to know with certainty whether they're in compliance with the law as they go about their daily lives. You could be legally carrying your firearm in one jurisdiction, cross an invisible municipal boundary, and suddenly be committing a crime without any change in your behavior or intent. This is the kind of regulatory complexity that doesn't happen by accident. It's designed to create confusion, to discourage people from exercising their rights because the risk of accidental violation becomes too high. Now let's talk about the liability provisions for gun manufacturers and dealers, because this is where the economic warfare against the Second Amendment becomes most apparent. These laws create pathways for victims of gun violence to sue manufacturers and dealers under theories of liability that would never be tolerated in any other industry. Imagine if car manufacturers could be sued every time someone used a vehicle to commit a crime, or if knife manufacturers faced liability for stabbings, or if alcohol producers were held legally responsible for drunk driving deaths. We don't accept that framework in any other context because we recognize that the misuse of a legal product by a criminal doesn't create liability for the manufacturer who had no control over that misuse. But when it comes to guns, suddenly that basic principle of legal responsibility gets thrown out the window. The goal here isn't really about compensating victims or improving safety. It's about using the courts to accomplish what can't be accomplished through legislation. If you can't ban guns outright because of the Second Amendment, you can try to bankrupt the gun industry through litigation. You can make it so expensive to manufacture and sell firearms that companies either go out of business or exit the market entirely. You can create a chilling effect where potential new entrants into the industry decide it's not worth the legal risk. This is lawfare, plain and simple, and it represents a deeply cynical approach to policy making where the goal isn't to create fair laws that balance competing interests, but to find creative legal theories that can be weaponized against constitutional rights. And we need to talk about the enforcement mechanism here because that's where the rubber meets the road. How exactly are these laws going to be enforced? Who's going to be prosecuted under these new provisions? If history is any guide, it won't be violent criminals who already ignore existing gun laws. It'll be otherwise law-abiding citizens who make technical violations, who didn't realize they were crossing some new legal line, or who find themselves targeted by overzealous prosecutors looking to make examples. We've seen this pattern play out in jurisdictions with strict gun control laws. Regular people end up with criminal records for things like having a spent shell casing in their car from a range trip, or for carrying a firearm across state lines without realizing that their home state permit isn't recognized where they're traveling, or for violating some arcane regulation about magazine capacity or firearm features. There's also a class dimension to all of this that doesn't get discussed enough. Gun control laws disproportionately affect working class people and minorities who live in high crime areas and who have the greatest legitimate need for self-defense. Wealthy people in safe neighborhoods with private security and alarm systems can afford to wait through bureaucratic delays and pay for expensive permits and training requirements. They can afford lawyers to navigate the regulatory maze. But a single mother working 2 jobs in a rough neighborhood who needs a firearm to protect herself and her children, these laws make it harder for her to exercise her constitutional rights. They price her out of self-defense. And there's a historical precedent for this that should make us all uncomfortable. Gun control in America has always had roots in disarming populations that people in power viewed as threats. After the Civil War, black codes included provisions specifically designed to keep firearms out of the hands of freed slaves. In the early 20th century, gun control was explicitly promoted as a way to keep weapons away from immigrants and labor organizers. The rhetoric has changed, but the effect remains the same, making it harder for ordinary people, particularly those without wealth and political connections, to defend themselves. What's happening in Virginia isn't happening in isolation, and that's what makes this story so significant. This is part of a coordinated national strategy. Gun control advocacy groups, funded by billionaires like Michael Bloomberg, are pushing template legislation in blue states across the country. They're sharing legal strategies, pooling resources for litigation, and working to create a critical mass of states with restrictive gun laws that can then be pointed to as models for federal federal legislation. The goal is to normalize gun control, to make it seem inevitable, to create a political environment where the Second Amendment exists in theory, but is so hedged with restrictions and regulations that it becomes meaningless in practice for most Americans. And here's where I think the broader implications start to become really concerning, because this isn't just about guns. This is about the relationship between citizens and government, about whether our constitutional rights are truly inalienable or whether they're privileges that can be regulated into irrelevance by state legislatures. If the government can effectively nullify the Second Amendment through incremental regulation, what's to stop them from doing the same with the First Amendment or the Fourth Amendment or any other constitutional protection? We're watching a test case in how far states can push back against constitutional constraints, and the outcome is going to have ramifications far beyond gun policy. The response from gun rights advocates in Virginia has been vigorous, as you might expect. There are already legal challenges being prepared, and organizations like the Virginia Citizens Defense League are mobilizing for both litigation and political action. County sheriffs in rural areas have indicated they have serious concerns about enforcing some of these provisions, and there's talk of sanctuary county resolutions similar to what we saw after previous rounds of gun control legislation. But the reality is that this is going to be a long fight, and it's not clear which side is going to prevail in the end. The Democratic majority in Richmond has the votes to pass these laws. The governor is willing to sign them, and the state's attorney general is prepared to defend them in court. Gun rights supporters have the Constitution on their side, but they're fighting an uphill battle against well-funded opposition and a political establishment that views gun control as a moral imperative rather than a constitutional question. So where does this leave us? It leaves us with a situation where Virginia has become ground zero for one of the most fundamental political and constitutional struggles of our time. The question isn't really about background checks or waiting periods or liability provisions. Those are just the specific policy manifestations of a deeper conflict. The real question is whether the American people are going to tolerate a system where constitutional rights can be regulated into near meaninglessness by state governments, where the protections enshrined in our founding documents become conditional and contingent rather than absolute and inviolable. The answer to that question is going to be determined not just by courts and legislatures, but by whether ordinary Americans care enough about these principles to push back, to organize, to vote, and to make their voices heard in a political process that often seems designed to ignore them. What happens in Virginia matters because Virginia is the template. If these laws stand, if they survive legal challenges, or if those challenges drag on long enough that the political will to resist fades, then you're going to see the same playbook rolled out in every blue state in the country. And eventually, the goal is to build enough momentum at the state level that federal legislation becomes politically viable. That's the end game here, and it's being pursued with patience and strategic sophistication by people who understand that fundamental transformations don't happen overnight. They happen through incremental steps that each seem reasonable in isolation, but that add up over time to something much more significant. The story of Virginia's new gun control laws is really the story of American constitutional democracy at a crossroads, facing questions about power and rights and the proper relationship between government authority and individual liberty that are as old as the Republic itself, but that feel particularly urgent right now in this moment of deep political polarization and institutional uncertainty.